Okay, everyone. My name is Jeff Donnelly, JP Donnelly. My website is jpdonnelly8.com. If you want to subscribe, hopefully you do. Subscribe to the channel, like the video, share the video. This video right here is my motion in support of my motion to dismiss the false gun charge that I'm facing right now for refusing to turn in a Class A license that was expired, and also for refusing to turn in my firearms that were actually in the state of Vermont and weren't even in Massachusetts. It's going to get all into it in the motion as I read the motion to you. Hopefully you enjoy the motion. If you want, a copy of the motion can be purchased for not much money, through PayPal, JP Donnelly 8, JP DONNELLY, the number 8 at AOL.com. Or you can also buy my book, Raw Motion and Political Repression, The True Tale of Massachusetts Bohemian. This book actually is a journal that details the illegal activities that were taken against me after I tried running for Congress as a common sense Republican. Long time ago. Okay, so let's get into it. Defendant's memorandum of law in support of defendant's motion to dismiss. And this is Springfield District Court, Massachusetts, criminal action number 2123CR002108. The defendant, Mr. Jeffrey Paul Donnelly, submits this memorandum in support of its motion to dismiss. The facts. The defendant, Mr. Jeffrey P. Donnelly, was first granted a Massachusetts Class A license to carry, firearm license, on September 17, 2009, from the city of Springfield, Massachusetts. For over the past decade, Mr. Donnelly has willfully complied with every legal request made by the Springfield Police Department in regards to his firearm license, even when the Springfield Police Department had been proven to be in the wrong. In the past, the Springfield Police Department had unlawfully revoked Mr. Donnelly's Class A LTC. In this case, Mr. Donnelly immediately abided by the deputy's order and then filed an appeal with the courts. The courts ruled that the city had acted improperly and returned Mr. Donnelly's Class A license to carry to him. Soon after, the Springfield Police Department had been ordered by the Springfield Superior Court Department to return to Mr. Donnelly his Class A LTC. Mr. Donnelly then had applied to the Springfield Police Department to renew his state business license, that being of a Commonwealth of Massachusetts hawker and peddler's permit, a business license that must be signed off by the police chief in the city town that one lives in. The clerk asked what he intended on selling. Mr. Donnelly stated that he intended to sell the book he wrote, Raw Motion and Political Repression. Raw Motion and Political Repression is a book that exposes corruption in the Commonwealth of Massachusetts. The Springfield Police Department retaliated against Mr. Donnelly and refused to sign off on the renewal of his hawker and peddler's permit application. Mr. Donnelly had never had any complaints during the year that Mr. Donnelly held an active hawker and peddler's permit, nor when he ran for mayor of Springfield or city council. Mr. Donnelly had campaigned by going door to door in the past, talking with residents. On March 31st, 2021, this year, Lieutenant Gasparini of the Munson Police Department called Mr. Donnelly on the phone and notified him that the Hamden County Assistant District Attorney had contacted him and told him to file charges against Mr. Donnelly for a complaint that was made in October of 2016. Yes, 5 years. Lieutenant Gasparini told Mr. Donnelly that he did not understand why the District Attorney's Office was compelling him to file the charges after 5 years. Mr. Donnelly contacted the Palmer District Court as well as the Palmer District Attorney's Office and the Maine District Attorney's Office in Springfield to ask about the possible charge. All of the mentioned parties said that Mr. Donnelly did not have any open cases. This was on a Wednesday. On April 2nd, 2021, being this year, the Friday leading into Easter weekend, at around 10 a.m., Mr. Donnelly received a phone call from the Munson police officer asking Mr. Donnelly if he was aware that Mr. Donnelly had an arraignment scheduled for 9:30 in the morning that day. Mr. Donnelly had not been aware of this due to the fact that just 2 days prior, the Palmer District Court had told Mr. Donnelly he did not have any open or pending cases, and that the Palmer District Court did not send or notify Mr. Donnelly of this arraignment date. The Munson officer asked if Mr. Donnelly would be able to get down to the Palmer District Courthouse that day. Mr. Donnelly informed the Munson police officer that he was on his way. The officer told Mr. Donnelly that he would tell the court that Mr. Donnelly was on his way, so a warrant would not be issued. April 2nd, 2021. Mr. Donnelly arrived at the Palmer District Court and an arraignment was held for indecent assault and battery. The Honorable Michael E. McCulkey, First Justice of the Palmer District Court, having read the whole case file, did not find nor order that Mr. Donnelly should have to refrain from possession of any firearm, rifle, shotgun, destructive device, or dangerous weapons. The Assistant District Attorney representing the Commonwealth did not request that Mr. Donnelly should have to refrain from possession of any firearms, rifles, shotguns, destructive devices, or dangerous weapons. Please see Exhibit 1, Mr. Donnelly's pretrial conditions in said case. Mr. Donnelly respectfully requested that his right to a speedy trial be granted in the Palmer District Court case. Springfield Detective Timothy Schenck claims in his narrative that on April 12, 2021, that Springfield Police Deputy Chief S. Kent issued a LTC and firearm revocation service for Mr. Donnelly due to an open case. Detective Timothy Schenck failed to include a copy of this revocation letter in his application for a warrant/criminal complaint. Quotes. Okay. Deputy Chief Kent did not, in fact, revoke Mr. Donnelly's Class A LTC, as is falsely stated. Detective Timothy Fink never claims that the Springfield Police Department ever attempted to serve Mr. Donnelly with the alleged revocation notice during any time that Mr. Donnelly had an active Massachusetts Class A LTC, being prior to April 25, 2021. The Springfield Police Department admitted that they never attempted to notify Mr. Donnelly that his firearm license was revoked prior to the phone call on May 7th, 2021. Once again, Deputy Kent did not revoke Mr. Donnelly's firearm license. You see, my firearm license was not revoked. Deputy Kent never revoked it on April 2nd like he claimed. Like the police officers who applied for the criminal complaint claimed. If Mr. Donnelly's firearm license was revoked on April 12, 2021, the City of Springfield, Massachusetts, failed to comply with the Massachusetts General Law, Chapter 140, Section 131F. Any revocation or suspension of a license shall be in writing and shall state the reasons thereforth. On April 22, 2021, Mr. Donnelly filed a motion to dismiss and a memorandum of law in support of his motion to dismiss. Mr. Donnelly hand-delivered a copy of both to the Hampden County District Attorney's Office, located within the Palmer District Court, and the Palmer District Court Clerk's Office, Exhibit number 2, being Mr. Donnelly's motion to dismiss without exhibits included. See, if you look at this, on April 22nd, I furnished the motion to dismiss that I read in another YouTube video to the ADA's office and to the court. On April 23, 2021, Mr. Donnelly sent in his paperwork to renew his Massachusetts Class A license to carry to the Springfield Police Department. In his renewal documentations, Mr. Donnelly makes clear his intention of relocating his firearms to the state of Vermont if his firearm license was not renewed. Exhibit number 3 clearly states in the last paragraph, in quotes, "I do not want to have to move my legally owned personal property, firearms, out of the Commonwealth of Massachusetts and have to store them where I am not present, as I am legally allowed to own firearms in other surrounding states." End quote. Mr. Donnelly's application to renew his Class A LTC clearly shows that Mr. Donnelly was unaware that the City of Springfield was informed of the criminal charges out of Palmer District Court, as Mr. Donnelly gives a rundown of what the Palmer case is. And Mr. Donnelly even offers to bring the case file and all of the information to the Springfield Police Department for them to take a look at it and look it over. See Exhibit number 3, which is my application for renewal. On April 24, 2021, Mr. Donnelly moved his firearms to the state of Vermont. As a result of this, being the last day before Mr. Donnelly's Massachusetts Class A LTC expired, and Mr. Donnelly wanted to stay legal and within the law. On April 25th, 2021, Mr. Donnelly no longer had a valid Massachusetts Class A LTC as it had expired on April 24th, 2021. The executive director of the Criminal History Systems failed to abide by the Massachusetts General Law, Chapter 140, Section 131L. In quotes, the executive of the Criminal History Board Systems Board shall send electrically or by first-class mail to the holder of each such license to carry firearms a notice of the expiration of such license not less than 90 days prior to such expiration, and shall enclose therein a form for the renewal of such license, end quote. If this letter had been sent to Mr. Donnelly would have renewed his Class A LTC upon receiving said letter 90 days prior to the expiration and around 60 days prior to the false charges in Palmer District Court being filed. April 29th, 2021. The City of Springfield's Police Department marks receipt of Mr. Donnelly's renewal application on said application, but then mailed Mr. Donnelly back his application with an uncashed check in violation of Massachusetts General Law, Chapter 140, Section 131, by failing to, in quotes, the licensing authority shall provide to the applicant a receipt indicating that it received the application. The receipt shall be provided to the applicant within 7 days of mail if the applicant was received by mail, end quotes. The City of Springfield's Police Department failed to comply with this section of Massachusetts General Law, shows that due to the City of Springfield's Police Department that Mr. Donnelly's license to carry was not extended as they have claimed, as they failed to extend it by refusing to follow Massachusetts General Law. Envelope post office dated sent May 6th, 2021 from the Springfield Police Department. The Springfield Police Department sent Mr. Donnelly back his whole renewal application, including his uncashed check for the renewal fee, with the inclusion of 2 documents, one being a Springfield Police LTC FID renewal application that differs from the official state application, with highlighted portions that state that the City of Springfield was requiring the following extra documents: a copy of a valid Massachusetts driver license, front and back, and a utility bill as proof of residency, copy of your current LTC, copy of your birth certificate, passport. Then they handwrote, please complete the attached form. The attached form asks for general information. This official letter document makes no mention of Mr. Donnelly having a revoked firearm license. And if you look at it, it's very classist because you have to have a valid state ID or a driver's license. You don't even need that you're not even required to have that to vote. Very strange. And this is a renewal license, not a brand new one either. May 7th, 2021, which is the very next day after they sent out this other letter. At around 5 p.m. on a Friday night, Mr. Donnelly was contacted by Springfield police officers, Detectives Timothy Sink and Sergeant E. Podolsky. In 2 separate phone calls, the officers informed Mr. Donnelly that his firearm license was revoked and that he had to turn in his firearms in Class A LTC to the Springfield Police Department. Mr. Donnelly at first politely informed the officers that his firearms were in Vermont, a state that he is lawfully allowed to own firearms in, and that he no longer has an active Massachusetts firearm license to turn in, as it had expired on his birthday, being April 24th. Yet they still continued to order that Mr. Donnelly go to Vermont and retrieve his lawfully owned firearms and turn them into the Springfield Police Department. Mr. Donnelly continued to tell them that he was not going to turn in his firearms, that they were located, going to turn in firearms that were in a location that he was legally and lawfully allowed to own them in, and in a location state that they had no authority over. Mr. Donnelly does admit that this conversation became heated. It became heated because the Springfield Police Department was attempting to violate Mr. Donnelly's civil rights and his rights under the Vermont state law and Constitution. Mr. Donnelly also refused to meet with the officers because it was a Friday night, and Mr. Donnelly feared that if he met with the officers, that they would have unlawfully arrested him for refusing to go to the state of Vermont in order to retrieve his lawfully owned firearms, in order to turn the firearms into the Springfield, Massachusetts Police Department. Mr. Donnelly feared being arrested on a Friday night and held until Monday in the Ludlow jail because Mr. Donnelly has had nightmares since he was unlawfully detained in said jail for 5 days. During these 5 days, Mr. Donnelly did not eat or drink anything and almost died as a result of it. In order to add more stress to Mr. Donnelly's deteriorating physical and mental state of being, they also left on a bright light 24 hours a day that the guards refused to dim or turned off, as well as refusing Mr. Donnelly anything to read, not even a Holy Bible, nor did they allow him church service or to speak to a priest. This was all done for posting on Facebook what had happened in open court. The offending Facebook post was a post exposing judicial corruption, and Mr. Donnelly ended up winning this case when it came to a jury trial. In fact, it was a 2-day jury trial, and I had every witness at the state, every witness that they brought up forward, admitting to committing felonies against me. None of them were ever prosecuted for it. And it took a jury less than a quote unquote lunch break to find me not guilty. If the Springfield Police Department had in fact revoked Mr. Donnelly's Massachusetts firearm license on April 12, 2021, whether Mr. Donnelly had agreed with the Springfield Police Department or not, Mr. Donnelly would have immediately complied and brought his firearms and license down to the Springfield Police Department, as he had done in the past, without issue. The only issue with this time is that Mr. Donnelly did not have a valid Massachusetts Class A license to carry to turn in, nor did he have any firearms located within the boundaries of the Commonwealth of Massachusetts. On May 10, 2021, Officer Joseph Broder filed charges as the complainant in docket number blah blah blah, even though Detective Timothy Sink is the person who wrote the narrative for this complaint. And Officer Joseph Broder had nothing to do with this incident. Detective Timothy Sink was upset with Mr. Donnelly, as he willfully and maliciously made false statements in his narrative to the Springfield District Court in order to have an arrest warrant and criminal charges issued against a law-abiding citizen of Springfield, Massachusetts. Detective Timothy Sink referred to 2 of Mr. Donnelly's handguns as being AK-47s. These are not AK-47s, but are antique Tokarev pistols, and were logged into CGIS as being that of firearm model TT33C, see Exhibit number 4. Firearm serial number AM-A867 and OD1131. Right. Detective Timothy Sink referred to a firearm serial number 1966AC2036 as an AK-47, when said firearm is listed into the CGIS system as a model WASR-10, see Exhibit number 4, which is actually listed as a sporting rifle and is not listed on any of the CGIS papers as being an AK-47. The firearm name AK-47 is a name that carries a negative image within certain groups of the population, including a lot of Democrats, including the ones such as the clerk magistrates in Springfield District Court. Detective Timothy Sink states on 4/12/2021, Springfield Police Deputy Chief S. Kent issued an LTC and firearm revocation service for Mr. Donnelly due to an open case, but does not state that the Springfield Police Department ever attempted to serve Mr. Donnelly with this notice prior to May 7th, 2021, thus making it appear as if Mr. Donnelly was hiding said firearms and license from the Springfield Police Department since April 12th, 2021. Detective Schenck also failed to include a copy of his notice in his application for a warrant and criminal complaint of this notice. So yes, they didn't even, include a copy of any notice at all about my firearm license being revoked to the court. Because guess what? The firearm license was never revoked. Big issue there. Detective Schenck states next, pursuant to the provisions of Chapter 140, Section 129D of the Massachusetts General Law, anointed, Mr. Donnelly refused to deliver or surrender to the licensing authority, Springfield Police Department, his LTC, firearms, large capacity feeding devices, rifles, shotguns, and ammunition owned by him or in his possession. Once again, Detective Schenck willfully fails to state that the firearm license in question is in fact expired, and as such no longer an active license, and that Mr. Donnelly had clearly explained that the firearm license was in fact no longer valid, and not a license because it was expired. Detective Schenck then states today, 05/07/2021, I, Detective Schenck, contacted Mr. Donnelly on his cell phone number. I spoke to Mr. Donnelly at approximately 1700 hours, and he stated he would not surrender his firearms and LTC to the police. Mr. Donnelly stated he was going to transfer his firearms to Vermont so he cannot obtain them. Mr. Donnelly was very uncooperative and argumentative on the phone. Mr. Donnelly was given plenty of opportunities to comply with the order. On 05/07/2021, at approximately 1720 hours, Sergeant E. Podolsky called Mr. Donnelly, who stated that he felt that he was not required to surrender his firearms and they were already in Vermont. Mr. Donnelly's story on whereabouts of his firearms and other related topics kept on changing, and again refused to comply with the order. Once again, Detective Schenck failed to state that the firearm license was expired and no longer valid, and that Mr. Donnelly had already stated his intention to move his firearms out of the Commonwealth of Massachusetts in his renewal application that had been provided on April 23rd, 2021. Mr. Donnelly's intention of moving his firearms out of state was well documented prior to this phone call and conversation. The Springfield Police Department never included in their application for this criminal complaint and warrant to issue any proper and or legal documents that Mr. Donnelly had an active Class A LTC on May 7th, 2021, and that is because I didn't have one on that day. The Springfield Police Department never included any proof that Mr. Donnelly had any firearms located in the Commonwealth of Massachusetts. Once again, they didn't even claim that I had firearms in Massachusetts, nor did they file for a search warrant, which they should have done. It would have showed that I had no firearms, but still, it would have been the proper route than filing, charges. Mr. Donnelly was not precluded from owning firearms as a condition of his pretrial release on this other criminal case in Palmer District Court. The Springfield police officers never disclosed who informed Deputy Chief Kent of the active charges, which honestly, I found out later on that it was one of the assistant district attorneys from Hampden County, which kind of shows that they were very upset that they didn't get that in the pretrial conditions, so then they backdoored around and were trying to do it through the Springfield Police Department in order to retaliate, obviously against, being served with that motion to dismiss, calling him corrupt. Mr. Donnelly found out that the individual who informed Deputy Chief Kent of the active charges against Mr. Donnelly, was a Hampden County Assistant District Attorney, but it is unknown what ADA is the one who furnished this information to Deputy Chief Kent. In fact, the ADA who furnished Deputy Chief Kent with this information actually provided Deputy Chief Kent with important documents that could help clear Mr. Donnelly in the Palmer case. The Hampden County District Attorney's Office willfully hid this information from Mr. Donnelly in the Palmer District Court case. The Hampden County District Attorney's Office actions of contacting Deputy Chief Kent was done in order to circumvent the Honorable Michael E. McCulley's first justice of the Palmer District Court's pretrial condition order in the underlying Palmer District Court case. At 12:01 a.m. on Monday, May 10th, 2021, Mr. Donnelly had started a hunger strike in order to bring awareness to the corruption. Said hunger strike was to take place at the Springfield Police Department, and the officers were aware of this Friday night when they had called Mr. Donnelly. This was to be Mr. Donnelly's second hunger strike. Mr. Donnelly was arrested on May 11th, 2021 without issue by the Wilbraham Police Department at around 3:30 a.m. at a gas station as Mr. Donnelly was making a tea. What can I say? I drink tea, I don't drink coffee. Mr. Donnelly was given a cash bail of $540 at around 4 a.m. but was not provided with any access to an ATM in order to use his debit card. An ATM was located next door to the Wilbraham Police Department, if not within the police department itself. The Wilbraham Police Department had placed Mr. Donnelly in a dirty cell that had obviously not been sanitized or cleaned in some time. This caused Mr. Donnelly great worry as he is a severe asthmatic and we are in the middle of a global COVID pandemic. The Wilbraham Police Department then transferred Mr. Donnelly to Ludlow Jail, also another hotbed for COVID. Even though by law the Wilbraham Police Department was supposed to bring Mr. Donnelly to court for an arraignment first thing in the morning, a couple of hours later. Mr. Donnelly was threatened by the captain with the use of deadly force, use of pepper spray that Mr. Donnelly had an allergy to, and is a severe asthmatic, against Mr. Donnelly because Mr. Donnelly respectfully stated that he would not wear a prison uniform as he was a political prisoner. Mr. Donnelly was tied down to a bed, had his clothing cut off of him, even though Mr. Donnelly was not physically struggling or resisting the officers. When I get the videotape of this, I'm going to be posting that because it's going to show that I complied completely. Alright, Mr. Donnelly was placed in a cell with bodily fluids all over it and that had obviously not been cleaned or sanitized in a very long time. As well as having stale air, this cell was not sanitized and was located in a COVID hotspot. The guards also took Mr. Donnelly's mask from him. The Ludlow jail refused to release Mr. Donnelly for several hours after he was ordered freed by Justice Payne of the District Court. The Hampden County Assistant District Attorney had first requested that Mr. Donnelly be released on a $500 cash bail, but during the arraignment hearing, she changed it from $500 to a $5,000 cash bail. This surprised Mr. Donnelly's public defender. Justice Payne released Mr. Donnelly on the following conditions: either surrender firearms to the Springfield Police Department or provide affidavit from person firearms were turned over to by 5/17/2021, and a personal reconnaissance $500 personal security bond. You notice that? Who the firearms were turned over to in Vermont. The firearms were not turned over to anyone. The firearms were still my personal property. I just removed them out of Massachusetts into Vermont. So with that means that the judge ordered that they be turned over to Springfield because there was no one, which means that he ordered firearms to be confiscated in the state where I was legally allowed to own them off of a criminal complaint that was based upon the firearms being moved out of state. Very illegal, very corrupt. Mr. Donnelly was not released until around 2 hours later after he had talked to a guard who had told him that just because a judge said he was released didn't mean that he could go home. After hearing this, Mr. Donnelly started banging his fists against the glass. After roughly half an hour of this, the guard came back to the window, and Mr. Donnelly informed the guard that he was going to do this until he shattered his hands, and that the prison would have to explain why Mr. Donnelly was still in their custody several hours after he was released. This was around 2 to 3 hours after Mr. Donnelly had been set free by Justice Payne. Mr. Donnelly was released soon after. Yes, I was willing to risk breaking both my hands in order to do this, because otherwise I was going to be held for God knows how long, especially since I was being held illegally. After that, Mr. Donnelly is not required by Vermont law to have his firearms turned over to anyone and to exercise his rights under the Fifth Amendment of the Constitution. Mr. Donnelly is not going to say if, who, or where in the great state of Vermont his firearms are located, but will only say that they are located within Vermont. As such, and as a result of other people not wishing to become involved, and for good cause and reason, as they fear backlash from the Commonwealth of Massachusetts if they were known. On Friday, May 14th, 2021, Mr. Donnelly contacted the Springfield Police Department in order to transfer Mr. Donnelly's firearms, as Justice Payne release order had commanded. Without a letter from a person in Vermont, even if his firearms were legally in Vermont, Mr. Donnelly had no other option than to bring them back to Massachusetts and turn them into the Springfield Police Department. Friday, May 14th, 2021. Mr. Donnelly called up the Springfield Police Department officers who had contacted him. The sergeant said that he had no idea who Mr. Donnelly was and had no idea about him turning in of his firearms. Then Mr. Donnelly went to the police station to talk to someone in person. Mr. Donnelly talked to someone who told him that he would not be charged a storage charge for his firearms, and then Mr. Donnelly asked if, when he arrived with the firearms, if he could drive into the Sallyport, actual building garage, in order to turn them in. This officer told Mr. Donnelly that the officer in charge of this case didn't come in until 4 p.m. and would call Mr. Donnelly when he came in. You see, I was doing my best to actually comply with the judge's order and go up to Vermont and turn in the firearms, even though it was an illegal order. The detective contacted Mr. Donnelly and told Mr. Donnelly that he would not be able to turn in said firearms because Mr. Donnelly did not have a Massachusetts firearm license, and it would be illegal for him to transport said firearms in Massachusetts. Mr. Donnelly explained that he had a court order from Justice Payne ordering him to turn over the firearms to the Springfield Police Department. The Springfield detective stated to Mr. Donnelly that the Springfield Police Department would send an officer to Vermont in order for Mr. Donnelly to surrender the firearms to the Springfield Police Department. Mr. Donnelly asked if they could do this either Saturday or Sunday because Justice Payne had ordered that they turned over before court on Monday. The detective then said that he could not get an officer to do it during the weekend, but could on Monday morning. Mr. Donnelly explained that he could not do it on Monday morning because Mr. Donnelly had to be at court at 8:30 in the morning. The detective said, "Are you sure you have to be there?" Mr. Donnelly said, "Yes. And if he wasn't, the court would have him arrested and he would have to pay a $500 fine." The detective and Mr. Donnelly agreed with the Springfield Police would go up to the Vermont on Wednesday at noon for Mr. Donnelly to surrender his firearms to the City of Springfield, Massachusetts Police Department. On May 12, 2021, the Springfield Police Department officers in video admit that they never attempted to serve Mr. Donnelly with the revocation letter until the night of Friday, May 7, 2021, even though it was issued on April 12, 2021. They also refused to provide Mr. Donnelly with a copy of the letter, and Mr. Donnelly refused to leave until they did, even though they were saying that them verbally informing Mr. Donnelly was all that they had to do. Mr. Donnelly quoted that the Massachusetts general law clearly states that it has to be in writing. One of the officers then went into the police department to get Mr. Donnelly a copy of the letter, the revocation letter. The letter that the Springfield Police Department provided Mr. Donnelly did not say that his license was revoked, but that it was only suspended until the case in Palmer District Court was resolved. This is in stark contrast from what the detectives had told Mr. Donnelly over the phone and what they had sworn to in their application for criminal charges and a warrant for Mr. Donnelly's arrest. Mr. Donnelly ended his hunger strike early on Wednesday, May 12, 2021, in order to fight this case. On Wednesday, May 19, 2021, Mr. Donnelly met with 3 Springfield police officers in the Vermont State Police parking lot in order for the Springfield, Massachusetts Police Department to confiscate Mr. Donnelly's firearms. As a result, the Massachusetts District Court judge's order allowing Mr. Donnelly's release from the Ludlow jail, and in disregard to Mr. Donnelly's rights under Vermont state law, as Mr. Donnelly is lawfully allowed to own and possess firearms in the state of Vermont. Mr. Donnelly, being a law-abiding citizen, turned over all of his firearms, including firearms that were not listed on the list provided by the Springfield Police Department. Issue number 1. Now this goes into the legal issues. What I already read was the facts of the case. These are the legal issues and arguments. Issue number 1, the Springfield Police Department made improper service when they claimed that they revoked Mr. Donnelly's Class A firearm license in violation of Massachusetts General Law, Chapter 140, Section 131F. Argument number 1. The Springfield Police Department clearly violated the Massachusetts General Law and how they claimed to have revoked Mr. Donnelly's Class A LTC. The Massachusetts General Law are very strict and direct on how a Massachusetts firearm license is to be revoked or suspended. Under Massachusetts General Law, Chapter 140, Section 131F, it clearly states, in quotes, "Any revocation or suspension of a license shall be in writing and shall state the reasons therefor," end quote. Detective Timothy Shink clearly states that Mr. Donnelly was notified of his license being revoked by a phone call. A phone conversation is not in writing, Detective Schenck and other police department employees could have hand-delivered, left written notice at Mr. Donnelly's residence, or could have even mailed Mr. Donnelly a letter informing him of his license being revoked. In fact, the city's police department could have included such a letter in the letter that they sent Mr. Donnelly on May 6, 2021, and any of these methods would have been legal under the Massachusetts general law. But they opted to place a phone call instead, something that is not allowed under the Massachusetts general law. But what is more worrying is, why did the Springfield Police decide to wait almost a month after to attempt to make service? On video, the Springfield police officers state that the night of May 7th, 2021 was the first time that they attempted to contact Mr. Donnelly about his firearm license being revoked, even though it had only been suspended. Also to note, in Victor versus a Juvenile versus Commonwealth 423, Mass. 793, October 9th, 1996 through November 14th, 1996, Suffolk County states, quotes, "We state with the proposition that where the statutory language is clear, the courts must give effect to the plain and ordinary meaning of the language." End quote. Commonwealth versus 1987, Mercury Kruger Auto, 413, Mass. More quotes. And case cited, Rembert versus Commonwealth, 389, Mass. 771 to 773, 1983. In quotes, "The language of a statute is not to be enlarged or limited by construction unless its object and plain meaning require it." End quote. The Massachusetts general law in this case clearly states that notice has to be in writing, and it is clear that notice is to be in writing in order to limit misunderstandings from happening, such as the misunderstandings that we have in this case, wherein the detective claims that Mr. Donnelly's Class A LTC license was revoked, when it was not actually revoked, but suspended until the Palmer case was resolved. Mr. Donnelly is respectfully requesting that this case be dismissed because, given the above reasoning, Mr. Donnelly has violated no laws or statutes. Okay, now issue number 2. Mr. Donnelly had given notice on April 23, 2021 to the Springfield Police Department that there was the possibility that he was going to move his firearms to Vermont, and had also told Detectives Timothy Schenck and Sergeant Podolsky on May 7, 2021 that said firearms had been relocated to Vermont, a state that Mr. Donnelly was allowed to own firearms in. As a result, Mr. Donnelly had no firearms located within the Commonwealth of Massachusetts to turn into the Massachusetts law enforcement. Argument number 2. On May 7th, 2021, Mr. Donnelly had not only told Detective Timothy Schenck and Sergeant Podolsky that he had moved his firearms to Vermont, but had also written in his Class A license to carry renewal application that was sent to the Springfield Police Department on April 23rd, 2021, and filed on April 29th, 2021, that Mr. Donnelly didn't want to move his firearms out of the Commonwealth of Massachusetts, but had intended on moving his firearms out of concerns of possible issues with his renewal as a result of the open Palmer case, even though that case was from 5 years prior. Mr. Donnelly had known that if he would have waited and been denied his renewal due to the open case, that Mr. Donnelly would have had to turn in his lawfully owned property. So in order for that to not happen, and to stay within the laws of the Commonwealth of Massachusetts, Mr. Donnelly forewarned of the actions that he was intending on taking. So it wouldn't be a surprise to the City of Springfield Police Department when they found out that Mr. Donnelly had no firearms located in the Commonwealth of Massachusetts. When one takes actions such as this, they take said actions prior to the other party knowing of said activity, such as with Mr. Donnelly sending in his application package the day before he moved the property out of state. At no point in time do the Springfield police officers claim, allege, or can prove that Mr. Donnelly has any firearms or had any firearms in the Commonwealth of Massachusetts, but they do state that Mr. Donnelly has stated that they were located out of state, as Mr. Donnelly had stated in his renewal application, and now we have the City of Springfield's Police Department going into and confiscating Mr. firearms in the state of Vermont, even though Mr. Donnelly is not precluded from owning or possessing firearms in said state, as his pretrial conditions clearly do not preclude it. The City of Springfield's Police Department's willingness to travel to the state of Vermont in order for Mr. Donnelly to turn in his firearms to them per Justice Payne's court order proves that the City of Springfield is aware and fully believes that Mr. Donnelly did in fact move his firearms to the state of Vermont as he had stated to them. The Springfield Police Department did in fact confiscate Mr. Donnelly's lawfully owned firearms in Vermont in violation of Vermont state law. The Springfield Police Department officers waiting 5 extra days after Mr. Donnelly agreed and was trying to turn over said firearms to them proves that the Springfield Police Department had no beliefs that Mr. Donnelly was going to do anything improper with said firearms. As if they did, they would have gone to Vermont to take custody of said firearms at their very first chance. This proves that the City of Springfield, Massachusetts does not fear that Mr. Donnelly is going to do anything improper with said firearms, as not only were they not willing to send someone up until midweek, but they were also not willing to allow Mr. Donnelly to deliver the firearms to them, even though Mr. Donnelly had said that it was legal because he had the court order from Justice Payne. Mr. Donnelly is respectfully requesting that this case be dismissed because, given the above reasoning, Mr. Donnelly has violated no laws or statutes. Okay, issue number 3. On May 7th, 2021, Mr. Donnelly was not the holder of a valid Massachusetts Class A license to carry, as his license had expired on his birthday, April 24th, which is exhibit number 5. And the Springfield Police Department improperly processed Mr. Donnelly's Class A LTC renewal. Argument number 3. In the Commonwealth of Massachusetts, once a license or an identification card, passport, or firearm license is expired, it stops being valid for even identification purposes. With an expired license of any sort, you are not allowed to buy a drink, pack of cigarettes, or even to enter a state or federal building. Expired licenses are treated as just a worthless document. So if said document is worthless, why would one be forced to turn over an expired Class A LTC? Even when you renew your Class A LTC, you do not turn in your old one. When you get a new one, because it is just like any other expired license, just a piece of colored plastic with writing and a picture on it. And truth be told, Mr. Donnelly believes that the only reason why the officers wanted to meet up with Mr. Donnelly to collect his expired license was in order to harass and or threaten him into traveling to Vermont and retrieving his lawfully owned firearms and delivering the firearms to them, just as they had used the courts to do, just as they had ended up using the courts to do. Also to note, Mr. Donnelly believes that if he would have met with the officers in person, that the officers would have unlawfully arrested him because Mr. Donnelly had moved his firearms out of the Commonwealth of Massachusetts. The only reason why Mr. Donnelly had agreed to turn over his firearms to the Springfield Police Department is because if he had not, then Justice Payne would have revoked Mr. Donnelly's conditions of release in this case, thus taking away Mr. Donnelly's freedom and sending Mr. Donnelly back to Ludlow Jail, being a location where he has had nightmares since he had been illegally sent there years ago for posting on Facebook what had occurred in court, thus exposing judicial corruption. Mr. Donnelly had been tortured then, and this time Mr. Donnelly had been threatened with a deadly weapon and was tied to a bed and had his clothing cut off while the guards filmed it. The jail staff also refused to release Mr. Donnelly from their custody for over 2 to 3 hours after Justice Payne had ordered Mr. Donnelly's release. Mr. Donnelly is respectfully requesting that this court case be dismissed because, given the above reasoning, Mr. Donnelly has violated no laws or statutes. Issue number 4. Clerk Magistrate John Stocks allowed this case to be filed without a showing of probable cause. In fact, it appears as if the Clerk Magistrate just rubber-stamped this case, as the City of Springfield's officers failed to include any supporting documents in order to back up what they are claiming. Argument number 4. Firstly, Springfield officer Joseph Broder claims that he is fearing that Mr. Donnelly is going to commit a bodily injury to someone, yet there is no mention in the application of who or why the officer believes that Mr. Donnelly is going to do bodily harm to. Then he also checked off commission of a crime. It is also not mentioned what crime he believes that Mr. Donnelly has or is going to commit, especially seeing that Mr. Donnelly no longer had a Class A LTC to turn in, and he has stated that his firearms are located in a jurisdiction where he's still allowed to own and possess them in. Then he also checked off that Mr. Donnelly is a flight risk, when Mr. Donnelly has never left New England in his whole life. Then the officer checks off that he wants a warrant to issue for Mr. Donnelly's arrest because, as the paperwork states, quotes, "Warrant is requested because prosecutor represents that accused may not appear unless arrested," end quotes. To check off requesting for a warrant to issue in the case of someone like Mr. Donnelly is completely rubbish, because not only does Mr. Donnelly have a history of appearing, but he has a long history of appearing to all of court cases, including a case that he had just filed over to all of his court cases, including a case that was just filed a little over a month prior, and which he was given no prior notice to, but still showed up within a couple of hours of being informed of the arraignment. Clerk Magistrate Stocks had full access to this information and should have taken Mr. Donnelly's history of showing up to court into consideration, and should not have issued a warrant for Mr. Donnelly's arrest in this case. It should also be asked of Clerk Magistrate John Stocks, where in the application for a criminal complaint does the police officer make any allegations that Mr. Donnelly is an immediate threat, is going to commit a crime, or is a flight risk, as Clerk Magistrate John Stocks is alleging when he decided this application without notice to the accused. Because in the police narrative, all that it says is that Mr. Donnelly was refusing to give the officers a piece of laminated plastic, and that he had moved his lawfully owned property to a neighboring state, where he is illegal to own said property. Nowhere in the application for criminal charges does it say that the officers are fearful of Mr. Donnelly, or that they believe that he is going to commit a crime or harm anyone with said firearms. Nor do they claim that Mr. Donnelly is a flight risk in their statements. The Springfield Police Department failed to provide any documents, nor did Clerk Magistrate John Stocks request to see any documents in this case. It appears he just rubber-stamped the criminal complaint and warrant, thus causing a due process violation. If he would have done his due diligence in this case and requesting documents, he would have noticed that the firearm Class A LTC that the police officers were referring to was in fact an expired license and was no longer active. He would also see that even though it is alleged that Chief Kent had revoked Mr. Donnelly's Class A LTC on April 12, 2021, that the Springfield Police Department had not even attempted to make service of this revocation until May 7, 2021, being the night in question. If Clerk Magistrate John Stocks would have either been provided with this documentation or requested this documentation, he would have noticed that the police officers were lying by claiming that Deputy Kent had revoked Mr. Donnelly's Class A LTC, when in fact he had only suspended it. A suspension and a revocation are not the same thing, nor are they interchangeable in Massachusetts general law, or in law in general. The Springfield police officers make mention that Mr. Donnelly had stated that the firearms had been moved out of the Commonwealth of Massachusetts into the state of Vermont. If this had been true, then Mr. Donnelly would have been completely within the law. The city of Springfield had and furnished no proof that Mr. Donnelly had not removed his personal property from the Commonwealth of Massachusetts, as he had stated to them, and instead of requesting a search warrant for said property as would have been proper, the Springfield Police Department was in fact requesting to take Mr. Donnelly's personal firearms away. It is clear to see that the Springfield Police Department was well aware that Mr. Donnelly had removed his firearms from the Commonwealth of Massachusetts, and were more interested in taking Mr. Donnelly into custody in retaliation for his removing his personal property from the Commonwealth of Massachusetts. What also needs to be addressed is the violation of Mr. Donnelly's Fourth Amendment rights in this case, as the Fourth Amendment clearly states, in quotes, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized." End quote. In this case, Mr. Donnelly's arrest was an unreasonable seizure, as no probable cause was provided for this action. For the application of such a search warrant, for the application of a search warrant, possibly, but not for Mr. Donnelly's arrest. Mr. Donnelly is respectfully requesting that this case be dismissed because, given the above reasoning, Mr. Donnelly has violated no laws or statutes. Oh, we're almost over. Wow, might even be under an hour. Go figure. Compared to 3 hours for the other one. Issue number 5. Springfield Detective Timothy Schenck knowingly filed this report without a showing of probable cause. In fact, Detective Timothy Schenck had placed into his narrative misleading statements of fact and even willfully failed to provide proper documents within his complaint narrative. Argument number 5. What must be stated is that Detective Schenck failed to include any documents in his criminal complaint application package. This is highly suspicious, as these relevant documents are what help clerk magistrates decide if probable cause for a complaint to issue exists. Detective Schenck falsely claims that Deputy Chief Kent revoked Mr. Donnelly's Class A LTC on April 12, 2021, when in fact Deputy Chief Kent merely suspended it until the case in Palmer District Court concluded. In law and in life, there is a big difference between a suspension and a revocation. These two words are not interchanging, and a revocation is a more serious of the two. Detective Schenck also fails to not only include the paperwork, but also fails to mention that the Springfield Police Department never even attempted to serve Mr. Donnelly with the suspension letter, as is required by the Massachusetts general law. Detective Schenck also falsifies in his application what type of firearms Mr. Donnelly owns. It can only be thought of as to make it appear that Mr. Donnelly owns what some people have classified as so-called bad guns, scary guns, black guns. You see, Detective Schenck makes reference of 3 of Mr. Donnelly's lawfully owned firearms as AK-47s. 2 of these so-called AK-47s are simple antique Romanian-made Tokarev TT-3 pistols, which are very similar to the United States 1911 .45 pistol, and developed in around 1933. And the other, which are antiques. And the other firearm listed as an AK-47 is a Romanian sporting rifle, model name Warsaw 10. None of these firearms are listed in CJIS as being AK-47s, meaning that Detective Schenck took it upon himself to label them as such. In fact, every firearm other than the 2 Tokarev pistols / Warsaw 10s and the 2 SKS rifles, Detective Schenck only lists them by the caliber round that they fire and the company that produced them, showing that his labeling these firearms as he did was clearly done in order to bring negative attention to them. You see, the Tokarev pistols should have been listed as Romanian, and they should have had the caliber on them, and the SKS rifles should have been listed as Chinese with the caliber rifles that they fired as well. And the Warsaw 10 should have also been listed as a rifle, and it should have had the caliber that it fired as long as with Romanian for where it was produced. That is, if he would have gone the way he went with all of my 9mm and 38 special pistols. But you see, he wanted it to look like I had more deadly weapons than I actually did, in order to give a negative look to it for the clerk magistrate. Detective Schenck never makes mention that Mr. Donnelly's Class A LTC was in fact expired, nor does he provide any documents concerning Mr. Donnelly's Class A LTC, thus making it appear as if Mr. Donnelly is walking around with a valid, unexpired firearm license. Detective Schenck failed to inform the clerk magistrate in his statement or with a document that Mr. Donnelly had already notified the Springfield Police Department of his intentions of removing his firearms from the Commonwealth of Massachusetts in relation to his firearm license status on April 23rd, and filed with the Springfield Police Department on April 29th, making it most likely that Mr. Donnelly would have already removed his firearms prior to May 7th, just in case this was an issue with his renewal as a result of the Palmer case. The Palmer case was also why Mr. Donnelly had waited until April 23rd, 2021 to renew his permit, hoping that he could have the case dismissed prior to his need to renew. Now, see, that's what I was trying to do. I was trying to make sure I stayed legal, but at the same time of staying legal, I wanted to make sure I kept my property. Thus why, I took advantage of another state's laws, and as a United States citizen, I can do that. because Massachusetts is a very restrictive state and it actually violates people's civil rights. I kind of wonder what's going to happen with Massachusetts laws now that California's assault rifle ban was actually struck down, because Massachusetts' assault rifle ban is actually, gun laws are based upon that. Should be interesting. Okay, let's finish up. Mr. Donnelly had told both officers on May 7th that his firearms were in Vermont. Vermont is also where the Springfield, Massachusetts Police Department confiscated Mr. Donnelly's firearms from. Even though Mr. Donnelly was legally allowed to own firearms in the state of Vermont, if Detective Schenck would have truly believed that Mr. Donnelly had not brought his firearms to the state of Vermont, as Mr. Donnelly had clearly stated that he had done, then it is more likely than not that Detective Schenck or Sergeant E. Podolsky would have applied for a search warrant instead of an arrest warrant, because with the firearm license being expired and without proof of the firearms being located within the physical borders of the Commonwealth of Massachusetts, there's absolutely no probable cause for a criminal charge to exist. Mr. Donnelly is respectfully requesting that this case be dismissed because, given the above reasoning, Mr. Donnelly has violated no laws or statutes. Conclusion. As a matter of law, plaintiff Commonwealth of Massachusetts fails to meet even the minimum requirement, and as such, Mr. Donnelly respectfully requests that these charges be dismissed without delay. Dated the 24th day of May 2021. Respectfully submitted, Jeffrey P. Donnelly, pro se defendant. And the exhibits in this case are, number 1, order of pretrial release, docket number 214, 3CR 501. Number 2, motion to dismiss and memorandum in support of docket 214, 3CR 501, which is the Palmer case. Number 3, firearm license renewal that they sent back to me. Number 4, Commonwealth of Massachusetts Criminal History Systems Board Firearm Records Bureau, firearm sales, rental, lease transaction forms, which are basically for the 3 claimed AK-47s, showing that none of them are listed as AK-47s and that the model names for one of them is Warsaw 10, which is listed as a rifle, and the other 2 are listed as Tokarev pistols, while TT-33Cs, and they're listed as handguns, not AK-47s. Which means, where did the detective get AK-47s on any of that? It's obviously not in the siege's paperwork. And number 5, a copy of Mr. Donnelly's Class A LTC, showing that it's expired. And number 6, Deputy Kent's letter, which showed that was not a revocation letter, but in fact a suspension letter. Even though I didn't get it until later. Okay, not bad. We're under an hour on this. And once again, I'm asking you, it would really help me if you went out and bought a copy of this book on the internet. It can be purchased on PayPal, but through PayPal, jpdonnelly8@aol.com. You could find that at my website, which is jpdonnelly8.com. It's Raw Emotion and Political Repression, The True Tale of a Massachusetts Bohemian. You can make a donation to me at jpdonnelly8@aol.com through PayPal. You could purchase a piece of artwork or a print of mine, a poem. Yeah, I do write poems, go figure. Or you can make a purchase of one of the copies of one of my motions. You know, anything that you can do can help. And what I'm doing is I'm actually fighting for people's rights to own firearms and to possess firearms. I'm actually fighting the system, trying to make a difference for us, for everyone. I don't like when the system interferes with people's civil rights. You know, like, I could have moved out of state. I choose to stay in Massachusetts and fight the good fight. I mean, verbally fight the good fight, not physically. You know, there's a lot more information that's going to be coming up soon, because I was supposed to have my motion to dismiss in Palmer District Court, you know, like a couple days ago. But instead of allowing me my motion to dismiss in that case, I was assaulted, thrown in the holding cell, and brought back up there hours later after the ADA handling the case had left. You know, for an arraignment, for... Trust me, it's going to be strange and funny and crazy. And they bruised both the bones of my wrist, my knees, smashed my head against a few walls, and I wasn't even resisting. But yeah, when that information comes forward, it's going to be definitely interesting. Okay, have a great day.